Come on, our channel so GIIF Politics Avenue. Podcast of the training make making headlines. And a gym right now, EDB Exum, our Hoxie. And need to have Braxioma, say any ED can yam, so which must subscribe to the channel. It's a notification bell, so share now if you have for to answer into me and can be. Mr. say Yambo Ingram or a political highways in so Unia, a jet edema, and yet a sem to a crowd. Now, Ningana say a Professor Yao, Professor Ameyao, P.Kumfi. Sky Trace scandal. And in seminal equipee mu ewo court. Na unia enyasem koto akra. Eye a member of GIIF etimi akache court say $2 million be a course payment be a course without approval. Unia and also acquire charges for fraud. Yetimi edi abo eye Professor Ameya Kumfia. Asem no enya asem koto akra. Nti me no kasa die the case no palia and air pile up. Se wanye ntutu ye dia enhu nsem kan ye dia ene na court ebitimi ahye ne se onkoso. Ana se sika no ontua. Pray bargain eho. Mr. Say at this point in time, we breaking news at the amount and a projective flyer no at the ato a screen in so. And it was say Accra Sky Train Trial. Former GIIF board member tells court $2 million payment was never approved. And we and some Ahodoa Ekoso. Mr. Say young in some from na yenhe and also the yo edi emamo GIIF Politics Avenue
to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Akuffo versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Akuffo versus Bank of Ghana, Sito and other things came up and said that that was right. But the learning now, particularly after the case of Vincent Asefua versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Akuffo was declared, President Mahama was declared, and he was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Akufo-Addo from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo to take the seat, that would have been the order of the Supreme Court, and would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there is no court order restraining the president from nominating a Chief Justice, there's no court order restraining Parliament from processing the nomination of the President.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases. And please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. But that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything, and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974, provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean,
the court was happy that they had finally resolved the matter. It was basically a land matter, but what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted, or whether or not the case should start afresh. And the judges just kept being changed. until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court, that's about 5 layers, okay? Now, can we just...
We and some of the Timiko or channel so, Mamma was so jembre or had a sense of body, Eddie Adumbi Edominia. You have signed a bell room, na Yasumo Quantum so crowd. Aha, a GH politics, Ave.